The Federal and Vale Hospital jointly present the Madurai Marathon 2025. This event is co-presented by Walking Shoe Company and powered by PSNA College of Engineering and Technology and Tucker EV Chargers. Run for Bone and Joint Health on Sunday, December 21. Entry is free. All are welcome.
What about Sabarimala judgment? What Amit Shah says? It can't be implemented. Why not? Advani said, whatever be the judgment, we believe. Not the chief minister, not the governor, not the collector, no one. Justice Swaminathan did not follow judicial decision. Religious right is curtailed to the extent to maintain public order.
Do you mean to say the judge has no freedom to inspect a place? Hello, Federal viewers. Welcome to a chat with former Justice Mr. Hariparanthaman of the Madras High Court. We will be talking to him about the ongoing controversial case in Tamil Nadu, Thiruparankundram Deepam lighting case. Hello, sir. Welcome. Hello. So, for the last 1 month, the court halls of the Madurai bench of the Madras High Court have been listening to various cases related to lighting a lamp in Thiruparankundram Hill. So, in this, one of the cases filed by petitioner named, right-wing petitioner named Rama Ravikumar, he wants a lamp to be lit and the state government, the HRNCE, is resisting. And the judge passed the order and asking the temple administration to light the lamp. But so far, his order has not been implemented. And the judge in the open court, he says he's very upset that the court order has not been implemented and the officials are not responding to him. As a judge, how do you look at the response of this serving judge?
There were 4 cases, totally 5 cases. One case is a different case, let us not. For all the 5 cases, he passed a common order on 1st December 2025. And third is the Karthigai Deepam day. Therefore, the last minute, you can't have a time to file appeal. That is the pattern. Therefore, you are pressurizing. I suppose if there is a judgment, you have to follow. Yeah. What about Sabarimala judgment? What Amit Shah says? It can't be implemented. Why not? Permit women to go. They said no. Whatever be the judgment, we will not permit women to go. Even when before demolition of Babri Masjid, Advani said, whatever be the judgment, we believe Rama's birth took place in a particular place in mosque. Therefore, no one can change it. Whatever be the Supreme Court says, we are not bound by that. That was the statement made. Here it is not so. I don't know. Tamil Nadu government did not take such a stand. I'm telling you. But the judge, the criticism against judge is, he passes order on the last minute, pressurizing to implement those orders in methods having connected or related to religion.
Okay.
Let us.
It's very sensitive.
Very sensitive, leads to law and order problem. Then there will be a riot. That is the whole issue.
But the judge says the state government is hiding behind the reasons like law and order, communal harmony. The judge points out that the state government is not interested in implementing the order, but hides behind the reasons like law and order.
So, very good. What I like to say is the same issue of lighting Deepam on the Karthigai Deepam day arose in 2014.
Okay.
In 2014,
similar situation was there.
Same. The issue is there was a lighting. Now also on 3rd December, the Murugan temple lighted Deepam at a particular place. It is not the judgment of Swaminathan about that. He said, besides that usual place, you also light Deepam at a place near to Dargah. The whole issue is near to Dargah. That is the whole issue. Now he has said. Earlier also an attempt was made in 2014. In fact, it relates back to 94. But 94 may not be much relevant. But first debate on Deepam in 94, judgment in 1996. But all the judgment, 96 or 2014, as far as 2014 is concerned, it went appeal. Two division bench judgments. Two division bench judgments said 1, 2, 3. I like to say number 1, place where the light has to be lit, the Deepam has to be lit, has to be decided solely by the temple administration. No one, not the chief minister, not the governor, not the collector, no one, or supreme, whoever. It is for the temple administration to decide
Okay.
where to lift. It is based on the usage, practice, and custom. One, the lighting of Deepam has to be decided by where to lit. Has to be decided by temple.
Temple administration.
Temple. Number 2, he said, law and order is a relevant issue.
Okay.
Number 3, communal harmony should be preserved. You kindly see that is a one-page judgment. Then in December 2017, Justice Kalyana Sundaram and Bhavani Subbarayan bench gave a little bit a longer judgment. They extracted this para.
Okay.
And they said what was argued was the lighting at Uchipilayar Koil, it is called the Moksha Deepam. Moksha Deepam is it is against Ahamas. If you are lighting at that place, they rejected that argument.
Okay.
They said, so sorry, if they are lighting at that place for more than 100 years, we don't want to interfere with the practice. And they also said it is the communal harmony is maintained. We don't want
Communal harmony is supreme.
maintained. We don't want to disturb that. These are the word used by those benches. Why he shows that kind of urgency in these matters? Does he show urgency in other matters? That is, does he show any urgency in other matters like this? I just want to know. That is one. This should be taken into account. Therefore, normally what they do, there is a 30 days for filing appeal.
Yep.
So even thereafter, Supreme Court is there. Therefore, what is the urgency? He says, well, first,
Many supporters of the judge, Justice Swaminathan, says he had disposed close to 1.5 lakh cases, including 73,000 main cases in the span of 8 years. And, his work reflected a high degree of impartiality, honesty, and integrity. This is the argument placed by supporters of senior advocates who support Justice G. Swaminathan.
Don't look into numbers kindly.
Okay.
How many judgments Justice Krishnan had disposed? Do you have any idea?
No.
He disposed 600 cases. 600 epics. In my view, every judgment is epic. And something like you cannot ignore anyone, whether
It echoes forever.
forever. Therefore, I am not on the numbers. What I wanted to say is in those judgments, did he show this type of urgency? Those cases are not, all the cases are not related to religion. In those cases, suppose it is a case relating to pension for a widow. Had he said, the collector, I will say, give tomorrow the pension. Otherwise, you have to come day after tomorrow. Did he say? Justice Swaminathan did not follow judicial discipline.
Okay.
Because in the case of, in Karur case, he simply ignored the division bench. Could he do that? In this case also, in same Thiruparankundram, he disregarded 2 division bench judgments on the same subject, same issue. Is it not a judicial indiscipline? What is your answer? One, that is one aspect. There are totally, I think there are 11 respondents. There are rules framed under Article 226 by High Court. That rule says, if for disposal of writ petition, time should be given for 3 months for filing counter.
Okay.
No, he says no. But of course, by consent of parties can be taken. But you can't force a person for a consent. That the many parties, they pleaded for time.
They wanted time.
They wanted time. They filed even memo seeking time.
Okay.
That does not reflect in the judgment. Is it not against the rules framed by the very same High Court? You can pass any interim order. The judges as pass any interim order, but not finally dispose. Even he has hundreds of contempt petition with him. Now he has hundreds of contempt petition, definitely.
All those cases are dealt in this way.
Just that no such urgency. Here, third lunch afternoon lunch time, contempt petition was filed in this Thiruparankundram case. He took it about 5 o'clock. When 5 o'clock, additional advocate said it's a premature, okay, at 6:05. Is it a way? Why you show such a type of urgency? Like a party, like the writ petitioner. Then the
So you mean to say he behaved more like a petitioner, not as a judge?
yes, definitely. But particularly these type of cases, he has certain ideology, original order.
Okay.
Yes, instead of temple administration, he said Ram Ravi Kumar can himself lead it. Number two, he can take 10% of his choice. Yes, his own ideology. This Ram Kumar also, he can take 10% of his choice. Number three, that is objection number two. My view is CISO will give protection. Central Industrial Security Force, that is supposed to give protection to the premises of High Court was directed, not the Tamil Nadu police. What is urgency? I don't understand. Therefore, he had a different yardstick for different issues.
Even
Therefore,
in his own cases.
his own cases. At same time, but that is happening same time. Therefore, there are three matters. One is Thiruparankundram. Number two is Dindigul Perumalpatti. Number three is Killiyur, Mailadumbarai, Paingulam. Now, all these three cases now are posted on 9th. All the three cases. But it's one case, but he passed orders on 9 in all, referring to all the three cases. This only one Thiruparankundram, but the cost title will show what is the case about. It refers to only Thiruparankundram, but in the order he deals with these cases also. It's a very peculiar thing. Of course, he does it. In that, in this 9-12 order, contempt matter, that you see the third, fourth, after fourth, it came on fifth, then fifth or ninth.
Is it a practice earlier followed by any judges
that nothing like this every day?
Bringing in different cases into the same
also
list?
Not taking contempt every day also never normally happens. You see, they will give a week time or 2 weeks time, something like that. They are not parties. I don't understand. But and also he uses the word, it's a political terminology. There is a total breakdown of law and order. It is for invoking Article 356 to impose precedent rule. Total breakdown of law and order. And also there is the machinery, constitutional machinery failed. These are all the terminology uses. Is it so? In Tamil Nadu, could you call it a total breakdown of law and order? Could you call it the failure of a constitutional machinery?
I would like you to explain on how in these kind of matters, in these kind of sensitive issues, when the case comprises religious practice, history, public order, so many things are intersected in that case. How a court decides on these cases? Do they usually weigh public interest with high priority? Do they weigh the agamic rules and history, religious, practice? Do they give more weight to those aspects?
It's a good question. I will have threefold answer. Number one, I already said, 2 division bench judgments said law and order is very relevant. No communal disturbance should take place. Communal harmony should be kept in mind. Number one, in the same issue. Number two, what is the constitutional right? What the Constitution speaks about? Article 25, the very beginning, it is giving you right to lead Deepam. It's your right to religion. Article 25 put a 3 condition, 4 condition, but let us take 3 condition. Number 1, public order, subject to public order, morality and health. That Karur case is relating to morality. What is health? Why there was no celebration during COVID? Because of health. Under Article 25, no one can say, sorry, I believe in God, therefore I want to celebrate. There should be a congregation. No one can stay during COVID because Article 25 put a condition, like public order. Therefore, government acted according to Article 25, in my view. Judge failed to act according to Article 25. Earlier, 2 bench acted in accordance with Article 25. And another thing is Section 28 of HRNC Act.
Okay.
That is what 28 says is it is the duty of the temple administration to administer
To take the call on any issues.
any issue, including this at that time, they have to look into usage, custom, practice. The 28 uses the word. Therefore, in my view, it is against 2 judges benches, two division bench judges judgment. Number 2, against Section 28 of HRNC Act, it is against Article 25 because public order is an important issue. You can't say again under the guise of public order you are not implementing. Yes, public order is very relevant. If suppose 4 people die, that is more important.
Public order is a
Public order
priority.
is very important. Yes,
That is the
yes,
priority.
religious right is curtailed to the extent to maintain public order. That is what Article 25 says. No one has absolute right. This is not absolute right.
Can we quote any other cases which were ruled like this, where the courts ruled for the public interest, public order, instead of giving all the importance to these kind of customary practice?
I said even in the same case, earlier judges quoted public order.
So, do you buy the argument that this particular case should have been heard by a civil court and not, should have been allowed as a writ proceeding?
One of the arguments by the other side, respondent, is if we say it is a practice, you have to establish before civil court. That's what. As far as the properties are concerned, these were decided as early as in 1923. A suit was filed in 1920. In 1923, Rama Iyer, subordinate judge, a civil judge, passed a detailed judgment that was ultimately upheld by Privy Council in London, 1923 judgment. He said the entire Thiruparankundram hill, as far as hill, a portion belongs to Muslims. A small portion. One is mosque. Number 2 is dargah. Number 3 is a place called Nellitho. One is, all the 3 are adjacent places. As far as Nellitho is concerned, that is surveyed, boundaries are fixed. That is what I am told. As far as mosque and dargah are concerned, the boundaries are not fixed. Justice Ilangovar of Madras High Court, I think in 2021, said you fix the boundaries, both temple and dargah agreed. Both here, in this case also, this Thiruparankundram, there is no fight between dargah and temple. It is the temple which says, no, we can't listen, we can't agree with this petitioner.
In the recent months, right-wing political party leaders say Thiruparankundram should be another Ayodhya, in the sense the Ayodhya of the south. But the local residents and traders are against this kind of comments. How do judicial orders help in avoiding the escalation of social tension?
A particular person, leader of a political party, a right-wing political party, BJP, he said, this will be turned into Ayodhya, he said this there. That is what 2 division bench said. Public order is irrelevant. Communal harmony is relevant. Already in same judgment they said, even in 1923, that was the very purpose.
Sir, in the recent months, there are several criticisms against Justice G Swaminathan all over the social media posts. Even the India bloc MPs, particularly the DMK MPs, they wanted to move the impeachment motion against Justice G Swaminathan, and they met the Lok Sabha Speaker with a request. Do you think the MPs are crossing the Lakshman Rekha between legislature and judiciary?
For the past 75 years, how many impeachment motions were moved? Now, there are 3 impeachment motions pending at a time within a 1 year. You see, number 1, Yashwant Verma of Delhi High Court, Shekhar Kumar Yadav of Allahabad High Court, and G.R. Swaminathan of Madras High Court at Madurai bench. There are 3 impeachment motions are now pending in the parliament. It is historic. Not in the 75 years, 3 impeachment motions are pending at a time.
Yeah, okay.
It's historic. Yes.
But don't you think, the justice, he explains everything, whatever, he climbed up the hill and he himself went there, saw the place where the Deepam was lit earlier, and the pillar which the petitioner wants, where the Deepam should be lit. Don't you think the justice is taking efforts to go there in person, study and observe, and don't you think he took those efforts to understand the issue better?
The allegation made by this respondent side is he made it clear in the court, I will alone go to inspection, no one should follow him. Is it correct?
Probably he wanted to do it with a lot of transparency. He wanted he did not want others to influence his decision.
Others, no, not others. The parties. No, you can say other than parties should not come. The parties, the petitioner should go, respondent should go, the counsel representing petitioner, counsel representing respondent.
Do you mean to say the judge has no freedom to inspect a place?
He can inspect.
When he is listening to the arguments, when he has to take a call, he wants to visit that place, and without taking any influence. Don't you think he is impartial?
No, the law, in my view, it contemplates, he has a right to inspect the place. I am not questioning his right. While he is inspecting, he can't inspect privately. He should inspect along with the parties to the case. That is the practice followed everywhere. It is a civil case. Always usually advocate commissioners go. He is like advocate commissioner. Therefore, the
courts appoint advocate commissioner in these kind of cases.
Yes, he acted as advocate commissioner. He himself. Instead of, he can also appoint a commissioner, go and see and give a report.
That is the practice.
Yes, practice. He went there, is fine. But he should take the parties. No, he did not. Number 2, the rule provides he should make a note, a record of his visit. Where is the record? That is the rule contemplates.
The Federal and Male Hospital jointly present the Madurai Marathon 2025. This event is co-presented by Walking Shoe Company, powered by PSNA College of Engineering and Technology and Tucker EV Chargers. Run for Bone and Joint Health on Sunday, December 21. Entry is free. All are welcome.